Hello all and welcome to this evening's webinar on Industrial Manslaughter Campaigning Brief. Before we begin, I'd like to respectfully acknowledge the traditional custodians of the Kulin Nations on whose lands we are presenting today and pay respect to their elders both past and present. My name is Roxanne and I am the online organiser in the OHS unit at Trades Hall, and today we are joined by Paul Sutton, lead organiser of the OHS unit. So welcome, Paul.
Thanks for having me, Roxy. Great to be here.
Excellent. All right, now let's get started outlining the session. So we'll start off with covering what is industrial manslaughter, a bit of a background to industrial manslaughter legislation or lack of legislation here in Victoria, why we want industrial manslaughter, what we are asking for, and how to get involved in the campaign. And as always, we'll spend the last 10 or so minutes having a bit of a Q&A session. All right, now just give me one moment. Beautiful, the screen should be coming up. Okay, so we'll go through a bit of housekeeping. We've taken a screenshot again of examples of your attendee interface. So this is what you should be looking at the moment. It's the desktop in the upper right corner, and you'll have the opportunity to submit any questions to to both of us today by typing your questions in the questions pane of the control panel. You may send in your questions at any time during the presentation, and we will collect these and address them during the Q&A session at the end of the presentation. If you can't see the question area in your webinar pane, you may need to expand it by clicking on the red arrow button. And you can raise your hand by clicking the hand icon on your panel, or if you'd like to ask a question, again, please enter it into the questions box as mentioned before, and you can see a blown up image of that as mentioned in the previous slide. And lastly, there's a handout section as illustrated in the screen. And this box contains all the resources that we'll be discussing in today's webinar available for you to download and keep. So all you need to do is click the link of the handout and it will automatically download for you on your desktop. As always, we will send copies of the slide and link to the recording in a follow-up email after the presentation. Okay. So, what is industrial manslaughter? So it's better termed corporate manslaughter. Industrial manslaughter is the crime committed when a company, through negligence, kills an employee. And just like any case of criminal manslaughter charged against an individual, industrial manslaughter encompasses jail time for the company who negligently kills a worker. So we'll just start off today's session with a quick little poll. All right, so our first poll is how many workers have died this year in Victoria? And your options are 3, 8 or 12. So give it a go and select which option you have, and at the end we'll tally some of those results. It may be a bit surprising to some of you may find it shocking, or some of you may already know some of the fatality counts this year, and we'll go through those a little bit later in the webinar. All right, so it looks like, Paul, I don't know if you can see that, we've got 100% who have selected 12 so far. No one selected 8 and no one selected 3, so this is a little interesting. All right, we're shaking it up a little bit more. All right, so it looks like everyone has responded. So I'm going to quickly close that poll. Oh, hang on, a couple more minutes maybe. It's jumping up and down. Do any of the results surprise you?
50-50.
50-50 on 8 and 12.
No, the results don't surprise me. I think everyone's aware that our fatality rate here in Victoria is way too high.
Yeah, so no one selected the lowest number, which is 3. So everyone's pretty on the ball with that. So I'm just going to close it quickly. All right, so we ended up with 57% of you saying we've had 8 fatalities this year, and 43% have selected 12. So, Paul, do you want to let the audience know how many fatalities we've had this year so far?
Unfortunately, this year we've had 8 people killed in Victoria. Most recently, there was a young man in his mid-30s who died last week as a result of a truck rollover on a farm out near where I grew up, actually, in Warrigal. So the farm's in Shady Creek. It's a bit outside Warrigal. And yeah, he passed away last week due to a truck rollover, which is really tragic.
Now, do you, I'm not sure if you recall, Paul, last year, is our fatality toll a little higher at this point in the year compared to last, or?
It's actually lower by one.
Lower by one.
The start to 2017 was quite horrific in many ways.
Yeah, there was a consecutive,
Yeah, there was a real spate of people killed at work early in 2017. That being said, you know, we knew it was a really bad start to 2017, but we've had exactly the same bad start to 2018. Nothing's changed. You know, fundamentally, you know, our view, or my view at any rate, is one death is too many. And the fact that we're having to sit here and talk about 8 is just appalling.
Yeah, it's a case in point to why we're going to be needing industrial manslaughter laws. So before we get into the campaign at large, we're just going to go through a bit of a background into some of like the bigger workplace fatalities we've seen in Victoria in the last 20, 30 years, and just touch on some of the changes to legislation that has affected. So on October the 15th, 1970, Victoria's worst industrial disaster occurred, and that was the Westgate Bridge collapse. And I know a lot of you may be familiar with that, or may have been around at the time it occurred. Maybe you were young. So just before lunch, the Westgate Bridge suddenly groaned. An eerie pinging noise filled the air, and a storm of rust flakes peeled off weathered steel. The girders started to turn blue. The bridge fell away beneath the feet of those workers there. 35 workers were killed that day, 18 were seriously injured, and countless others and their families were affected forever. Many of those were on a lunch break beneath the structures in workers' huts, which were crushed by the falling span. Others were working on and inside the girder when it fell. So at the request of the Premier at the time, a Royal Commission was held to determine the cause of the disaster. Now, this was a huge disaster. Like, from what I understand, it was heard from 20 kilometres away in the area. And it really did shock a lot of Victorians. And the conclusion of the commission was that the reason for the collapse was to be found in the acts and omissions of those entrusted with those building a bridge. And it was also a new, highly sophisticated design. So the various companies who supplied the materials used were not shown to be in any way at fault, and they were to be held blameless, according to the report. However, amongst those engaged upon the construction of the steel spans, there were a lot of miscalculations and errors of judgment, failures to communicate, and sheer inefficiency in a greater or lesser degree. So the Commission's findings, coupled with the long-standing fight of the union movement to create a safer working conditions for its members, that eventually paved the way for the strengthening of the occupational health and safety laws in Australian workplaces. So, Paul, did you want to just touch upon that?
Yeah, I will take people through that. Just quickly first, I'd just like to say every year there's a memorial service to remember those 35 people who died that day and the countless others who were injured. It's held at the Westgate Bridge, and it's a really great service. So if you're available on that day, think about getting on down. There's always a really large crowd of people. I think they're coming up soon to the 50th anniversary in a couple of years in 2020. So there'll be a big memorial of the Westgate Bridge collapse in 2020. Secondly, if you are interested in this kind of stuff, I studied out at Monash, and the civil engineering department out there has some of the old wreckage from the collapse installed out the front of their civil engineering department, because the obviously the Royal Commission concluded that part of the people engaged in the design of the bridge had caused some of the errors, and so they've appropriately stuck this twisted bridge out the front of where all the design students are learning, for them to remember that you know, when civil engineers get things wrong, it can put life at risk. So
because they use it as a lot of case studies for the students.
So if you want to see a bit of the wrecked bridge, it's out at Monash University in Clayton. But I now want to talk about the 1985 OHS Act. There'll be some of you out here who remember this, the act that preceded our current 2004 Act. Essentially, the Labor Party gained power in the Legislative Council in 1985, and they introduced a new bill, the Occupational Health and Safety Bill, which was passed. That bill was introduced in an attempt to prevent the number of injuries and deaths occurring across industries. It was also a turning point in that for the first time in Victoria, the Act allowed for elected health and safety reps who were given the right, amongst other powers, to inspect workplaces, access information relating to OHS, accompany inspectors, request the establishment of a health and safety committee, and of course, have the right to issue a PIN and even order that work cease. Very important act, it's laid a lot of the groundwork for our current act, and it started to enshrine health and safety reps in our OHS system. That legislation had its origins in the UK Robbins Royal Commission to Workplace Health and Safety, the recommendations of which were picked up in the ACTU policy in the early 1970s, and obviously as a response to things like the Westgate Bridge collapse, where it's clear there were grave failings and workers needed an act to protect themselves. And so as Labor won government around Australia, the main aspects were implemented in legislation, including that first 1985 OHS Act.
So the second larger event that happened in Victoria relating to quite a huge number of workplace fatalities was on September 1998, and that was the SOE Gas Explosion. So this explosion at the plant killed 2 workers and injured 8 more. And the fire at the plant was not extinguished until 2 days later. So when the plant was shut down immediately, the state of Victoria was left essentially without its primary gas suppliers, and gas to home and industry were severely affected for another 2 weeks. Now, SO blamed the incident on worker negligence, but the findings of the Royal Commission, however, found SO to be fully responsible. They stated that the causes of the incident on the 25th of September amounted to a failure to provide and maintain, so far as is practicable, a working environment that was safe and without risk to health. And this constituted a breach of Section 21 of the Occupational Health and Safety Act. So noting that when the Westgate collapse happened, we didn't have this enshrined into an act. And so by having the act passed in 1985, it allowed, the ability to
hold the employer to account.
Hold them, under Section 21 of the Act. So it was really important. This was a huge, win in terms of this ability to bring justice back in a kind of way, to be able to hold them account and say that there was a breach to some parts of the law. Now, SO was taken to the Supreme Court as a result of this, and the jury found that the company was guilty of 11 breaches of the OHS Act and imposed a record fine of $2 million in 2001. But no one received jail time. So that's really key here, because the Act then and the Act now doesn't stipulate jail time for breaches of the Act in this account. So following the Longford explosion, Victoria introduced a major hazard facilities regulations to regulate the safety at plants, and they're classified as major hazard facilities. So i.e. Facilities that have large quantities of hazardous chemicals. Now, these regulations impose a non-prescriptive regime on facility operators, requiring them to demonstrate control of major chemical hazards through the use of safety management systems and a safety case. So these and other incidents prompted the union movement to call for industrial manslaughter laws. And when the Bracks Labor government was elected in 2001, it supported the introduction of industrial manslaughter laws here in Victoria. When the bill was introduced in 2002, it was rejected, however, by the upper house after intense lobbying by businesses and other groups. The Labor government did not have control of the upper house at that time. So unfortunately, when Labor did not have control of the upper house after this until 2006, industrial manslaughter was not part of its platform.
In 2004, you guys will be aware we got a new OHS Act. In 2003, Chris Maxwell was commissioned by the Victorian Labor government to conduct an independent review into the 1985 OHS Act. At this time, unions fought for industrial manslaughter laws, but the government only agreed to a compromise which involved 2 changes to the Act. They gave us Section 32, reckless endangerment, and Section 144, liabilities of officers of bodies corporate. These changes were intended to be used together as a more pragmatic way of delivering the same results as industrial manslaughter laws, but the laws have only been used twice in the last 14 years, and one of those times they got used against an employee, not the employer, and no employer has been jailed as a result of Section 32 and Section 144. So our current laws don't actually target corporate negligence that leads to the death of a person, and that's why we're here today.
All right. So, Paul, why do we want industrial manslaughter?
Yeah, well, I mean, look at the screen there. You know, we've got Growcon. They have $286 million worth of profit or income. And we know that when they had hoarding incorrectly installed on a wall, that wall collapsed and killed 3 people, and they were fined $250,000. You know, we've actually got a poll on this. Who thinks that's a fair outcome? Who thinks that $250,000, a $250,000 fine was justice for those 3 people killed by that wall collapse?
Bearing in mind, what is it? Growcon's 2016 income was $286 million. All right, so we've got a 100% people saying no.
we thought it would be pretty big that way.
Yeah.
You know, this is why we need industrial manslaughter. This is why we want it. That was a complete injustice. There was no justice for those people, and Growcon, you know, goes on its merry way. And so we want a system that provides justice for the people who died and the family of the deceased. We want the issue in the workplace fixed. Current prosecutions result in fatalities. They result in fines that are too small, like the Growcon ones, few convictions. They don't target the senior decision makers. They ultimately send the wrong message. A workplace fatality for someone like Growcon just becomes the cost of doing business. Their negligence killed 3 people. They could have been fined up to $3 million, and yet they just received a $250,000 slap on the wrist. You know, the sign writing company, Aussie Signs, was also only fined $250,000, and that's not good enough.
No. Okay. So what are we asking for? Firstly, we want the law to say that it is a crime to negligently kill a worker. That's the number one point of the industrial manslaughter laws. The second point is that the law must be enforced and it must be prosecuted by the best organisation suited to that purpose. And we'll touch on that in a couple of slides. And the third point that we're asking for is that the law must stipulate jail time for CEOs or directors or senior managers whose negligence results in the death of a worker. So that point's very important. You'll notice that we didn't just say CEOs, we wanted to include senior managers. And again, we will touch upon that a bit further in the presentation. All right, so what will the policy say, Paul?
To begin with, we want a fault element of negligence. That's because it's a lower bar and easier to prove than either the gross negligence bar that's in the UK laws or recklessness as we currently have in our Act. So negligence is where someone fails to take the appropriate, provide the appropriate care in any given situation that a reasonable person would take. Gross negligence is when someone fails to take reasonable care in a manner that's well below society's expectations. And recklessness is really about when people know that what they're going to do is likely to kill someone. So it's a much harder bar to prove recklessness than it is to prove that someone didn't take adequate care in any given situation. So our aim will be to have a fault element of negligence in the industrial manslaughter laws.
I believe that means that most of our draft legislation will be based on the Queensland laws as they currently exist. And another element that we want to include in this is that the coroner's recommendations will be used for prosecutions as well. So that's a really important element to what we want to be asking for in this campaign. And what about the Crown?
Yeah, so technically under criminal law doesn't bind the Crown. So, for example, the Crown can't be accused of, say, blackmail or murder or something like that. So we want industrial manslaughter to apply to the Crown because the Crown is an employer. There are hundreds and thousands of people here in Victoria who work for the state government. They do, some of them do highly dangerous work, or can be put in dangerous positions due to the nature of the clients they have to work with. And it's appropriate that those people are also protected by these laws. So we're going to look to ensure that our draft legislation is written in such a way that it applies and protects government employees.
So who will prosecute? Now, I mentioned before in point number 2 that we want the law to be enforced and prosecuted by the best organisations suited for that purpose. And so if we were to put the law in the Crimes Act, then the Victorian Police and the Department of Public Prosecutions will be responsible for investigating and prosecuting. Whereas though if we were to put the industrial manslaughter laws in the OHS Act, then WorkSafe and the Department of Public Prosecutions will be responsible for investigating and prosecuting. Now, there are different pros and cons to each of these, so I'll go through them fairly quickly. So on the screen, we've got a bit of a table here outlining the pros and cons of having the industrial manslaughter laws put into the Crimes Act versus putting it into the OHS Act. Now, one of the pros to having it in the Crimes Act is that there's less likely to be swayed by political interference, because if the police are doing the prosecutions as opposed to WorkSafe, yeah, we have the understanding that it's not going to be as much affected by the government of the day. However, some of the cons to having it in the Crimes Act and having the police prosecute this is that the police, this is not, it's not core police business to be investigating manslaughter by corporations. It's common, obviously, for the police to be doing civil manslaughter, but not so much for corporate manslaughter. And one of the other core points was that there would be no appeals process, and that would be available if it were to be put under the OHS Act. And because the police aren't trained in OH&S, they're likely going to have to get assistance from WorkSafe anyway. So you're kind of cutting out the middleman if we were to bypass that and have WorkSafe prosecute this by putting it under the OHS Act. So of course, if we were to have it under the OHS Act with WorkSafe prosecuting this, they have the OHS experience in prosecuting. They know what negligence is and they know what negligence isn't. They already do prosecutions under the Act anyway. And of course, there's the option to be able to appeal the decision through Section 131 of the OHS Act. And of course, one of the other benefits to doing this through the OHS Act is that the unions do have say and consultation. They are one of the key stakeholders with WorkSafe through various committees and stakeholder reference groups. So we do have input in that, whereas though we don't have that kind of input and consultation and stakeholder engagement when it comes to anything to do with VicPol or I guess what's happening with criminal law. What else have we got to cover? So we've got the options of having it under the Crimes Act with VicPol prosecuting, or the OHS Act with WorkSafe prosecuting, or of course the third option is to have it in the OHS Act to have WorkSafe and the DPP to prosecute. So obviously you've got the same benefits as just WorkSafe doing it on their own, but we've got the benefit that the DPP, they're less likely to be swayed by the government of the day as well if they're doing the prosecuting. So that's pretty much the pros and cons of what we've decided to go through. And because of this, we believe that the law should be part of the OHS Act instead of the Crimes Act, and it would be investigated and prosecuted by WorkSafe because we believe that the best people equipped to do this and handle the issue.
So the next topic is who will be held accountable. As you've seen, our OHS Act has some stuff in it about officers of corporations being accountable. So An officer of a corporation is normally a director. And what that means is that for big corporations, directors might meet 4 or 5 times a year. They're not involved in the hands-on decision making. They're effectively immune with the way it's kind of, the personal immunity is granted to them via the distance from the job. So we need a way of kind of piercing the corporate veil so we can make individuals within the company accountable. And therefore, you know, if someone's made a decision who's of a significant, high enough rank, who's made a decision that's resulted in the death of a worker, that person can be personally liable. So we had a look at the different, pardon me, we had a look at the different schemes in various areas, and we found some laws in the UK that look like they're pretty good. And the UK talks about making senior management responsible rather than just the officers. So at the moment in Queensland, it's limited to officers as well. But the UK, they talk about senior management, in particular the people who make decisions about how the whole or a substantial part of the activities are managed or organised, or the actual managing or organising of the whole or a substantial part of those activities. And we like that phrase, actual managing, because then the person who's, you know, issuing the directions that govern a substantial part of those activities, like say the person in charge of the health and safety systems for an entire corporation, like they are on the hook. They are captured by that law because they'll be organising a substantial part of the activities and they'll actually be managing it. So it'll force those people to then have to think about, you know, if this decision is likely to end up with a fatality, do I want to be making it or do I want to be passing it up to the director? So it would start making those senior people in companies accountable for their decision-making processes. It would allow us to pierce the corporate veil so that individuals within companies can be held accountable for their decision-making processes. So we're proposing that we would follow the UK example of making senior managers accountable, because it casts a wider net than either the Queensland laws or ACT laws, which limit it effectively to the C-suite and above, the CEO, the chief financial officer, these kind of people.
Great. Now, before we just continue, I've just sent a little message to everyone through the chat box. For some reason, I'm not receiving any of the questions that are sent in through the questions box. So I've just asked if everyone can just make sure that any questions that they may have during the presentation that they want to be answered at the end, to just write them into the chat box. The chat box should pop up now that I've sent you a little message through that. So just bear that in mind. All right. So who will the industrial manslaughter laws cover? So under the Queensland laws, there would be no justice for the people who died because of the Growcon wall collapse, because it is limited to workers who are killed. So we want to ensure that members of the public are protected from dodgy bosses, so that we'll be using the term victim rather than worker in our proposed legislation.
So we've got a couple of exemptions that we're thinking about. This is about corporate industrial manslaughter, so corporate negligence. We don't necessarily want to capture some circumstances where it might be kind of a bit overboard to go down a industrial manslaughter path. One of those exemptions is the small family business. So what we're proposing is that we don't want a dad on a family-run farm being prosecuted when his son dies in a preventable quad bike accident in that farm. And if you've lost your own son, arguably you have been punished enough. But we do have a question for you guys that you might want to answer in the chat box there. Would we want small businesses covered if a non-family member, employee or contractor was killed through negligence?
So yeah, it'd be interesting to see what your opinions would be. So just type them into the chat box on your pane, and we'll get to them at the end of the webinar session during the Q&A.
And secondly, we don't want a firefighter in charge of an emergency response being charged for issuing orders in good faith and then something horrible happening. So a good faith defence exists for our emergency services workers in a number of areas. and it's appropriate that they also have a good faith defence here. And obviously, if you're fighting a fire, it's a really high pressure environment and you're having to make a lot of decisions. If you've made those decisions in good faith, then you shouldn't be caught by industrial manslaughter legislation.
All right, so I think we'll just run through a couple of case studies. Paul, did you want to touch upon that?
Yeah, sure. So I'll take you guys, first of all, through the redback tree services, and then we'll go through another case called CLN Infrastructure Proprietary Limited. It's important to realise these are both based on actual cases that WorkSafe has run. So these are the factual matters that we're looking at here are real factual matters, if you guess. So in redback tree services, you can see the background there. This is an arborist business, essentially. They cut down trees and all that kind of stuff. So a manager went out to a work site and he quoted the job. And when he quoted the job, he noted, like there was evidence, that he had noted nearby power lines close to the tree that they were being asked to work on. Because it's high risk work, it occurs at a height greater than 2 metres, and in this case it was also occurring close to power lines. There was a safe work method statement required by the OHS regulations. The company produced a safe work method statement. That safe work method statement noted that there was a risk of contact with the power lines, but failed to specify what controls should be implemented to eliminate the possibility of a worker colliding with a power line. They then went to the job. The power lines were neither suppressed nor shut down. So the two things that absolutely had to happen, either the power line suppressed or shut down to stop the current flowing through it, neither of those happened. The consequence was that a 22-year-old employee was killed when a branch he cut hit the power line, a risk that was known to the manager who quoted the job and the manager who put together the safe work method statement that 22-year-old relied on. So what we can see here is a real failure to take due care when setting up the system of work that this worker used. In the actual court case, the company pleaded guilty, they were convicted, and they received a $150,000 fine, which is just outrageous, absolutely outrageous, that this company effectively sent a 22-year-old person to his death, and they were convicted and fined $150,000, and nobody went to jail. Under our proposed laws, if there was the negligence requirement, if the senior managers were personally liable, we'd be looking at a completely different outcome in this matter, completely different. The company would be charged. They would face fines up to $15 million, a serious fine. The manager who knew of the risk of power lines, the guy who quoted for the job, and the person who put together the safe work method statement, they are potentially liable to be charged under our laws, as long as they've got control over a significant part of the business. And those individuals could face up to 20 years in jail. So those punishments are in line with the manslaughter punishments in the Crimes Act. So if you're guilty of manslaughter outside of work, you face 20 years imprisonment or fines of up to, if you're a company, up to $15 million. So the punishments that we're proposing match what the Crimes Act says, but in this case, under our current laws, it resulted in a $150,000 fine, but under our proposed laws, in this case, it's highly likely that the company would be fined millions of dollars, and the senior managers responsible would be potentially facing jail time for the kind of really egregious oversight that they engaged in. Total, very, it still shocks me, this case, so pardon the pun, I guess, but it is just outrageous. I find it appalling that, they wrote a safe work method statement that said there's a risk of contact with power lines and did nothing about it. That kind of negligence is likely to result in the bigger fines and the bigger jail terms under our proposed laws.
Yeah, as it should. All right, case study 2.
So this one's very different, and I'll take you through the background. Again, this is a real case, and actually I've got this case, so if people are interested in it, let us know through the chat function, and we can potentially put this case up into the webinar later on, so that you guys can have a look at it for yourselves. Essentially, this company, they were boring like a hole in the ground. Essentially, they had a drill, a big drill. Normally, the way this machine works, quite large machine, takes a couple of people to operate it. It's a big, heavy thing. They normally dig a pit, they secure it in the pit, and then they drill the hole into the ground. So these guys had successfully drilled the hole into the ground, and they had it all secured. When they were removing the drill, and they were removing when they were removing the drill rods from the hole, so retracting them back out, things got jammed and stuck. And at this point, the workers spoke to their supervisor, and they decided to try and break the drill rod using Stilsons, which are like really large shifters, basically. If you're familiar with a shifter, it's a large solid shifter, a Stilson. So what they ended up doing, these workers, is they actually moved the borer outside the pit, and they didn't secure. Normally in the pit, the borer is secured and it can't move around, but they had it outside the pit and unsecured. Or they tried to secure it with Stilsons, but ineffectively. What then happened was when they started it up again to keep retracting the drill rods, the borer shifted and it knocked a worker. That worker, as a result of that knock, fell against the back of a truck, and the collision, his fall against the truck, when he collided with the truck, he suffered fatal head injuries when he did so. The company had a really clear system of work, which was that drill rod breaking was to be done with the borer secured in the pit. They had a fairly thorough and good safety system, according to the court. So the court then made a number of findings here. And they said essentially that the breach was to not have a safe work method statement for the use of a Stilson to break a drill rod join. The court noted the activity had never occurred before and was outside the parameters of the training received by the employees. The court also held that the employee conduct was at the outer level of foreseeability, and there was no evidence of the company disregarding the safety of its workers. So in order to predict that this would have occurred, they needed to predict not only that the borer was outside of the pit and unsecured, but that there was a nearby truck that someone could fall into. So there was a number of things that had to go wrong that then resulted in the unfortunate death of this worker. Now, because the court found this was at the outer level of foreseeability, and that the company had no evidence of the company disregarding the safety of its workers, we think it's unlikely that this set of facts would result in a prosecution under our proposed laws. We think there'd be difficulty proving the causative nexus between the company's method of work and the death of the employee. And while the company pled guilty to a breach of Section 21 for failing to have a written procedure involving the use of Stilsons to break a drill rod join, that was still mitigated by the fact that the employee's behaviour was at the outer limits of foreseeability. So you guys who are HSRs will know when you do a risk assessment, you're trying to foresee the things that can go wrong, and you're putting if you've ever sat down and done one of those things, as part of it, you're asked to assess the likelihood of something eventuating on the basis of the the risk of what could happen and the likelihood of it eventuating, you determine an appropriate control. So, you know, in this case, when you compare it to the previous one, the Redback Tree Services, where they had a safe work method statement that outlined a clear present risk that could kill someone, the power lines, and then failed to control it. Like they literally failed to provide an adequate control for a foreseeable risk. Like that's a level of negligence that would qualify. Whereas when it's an unforeseeable risk or borderline kind of risk, it's going to be harder to demonstrate that there was negligence, particularly where the company's got a fairly good safety system otherwise.
All right, so we've just run through 2 case examples of what we think would be able to be charged under our proposed industrial manslaughter laws and what we think may not be possibly charged under the laws for the reasons laid out by Paul. So what we want to do now is just have a chat about how you guys can get involved in the campaign. So if you bear with me for a moment, I'm just going to pop up. One of the first things that we have is our online petition. And so what I'll do is I'll hand this over to Paul to just outline what the petition's about and how you can get hold of signing that petition.
So there's a couple of petitions running around. This one is one set up by the ETU that they set up last year. We've also got another one that Dr. Jerry Ayres has helped set up. So these petitions are essentially about making industrial manslaughter a crime. It's a way for us to start talking to people about how important this issue is, so that, because obviously, you know, we need to make as many people as possible aware of the injustices that are going on at the moment. And so basically our petition is a way for health and safety reps, delegates, people passionate about health and safety and industrial manslaughter to talk to people about why it's important that we have these laws here in Victoria. So yeah, we've got a megaphone petition that's going on. I think the Jerry Ayres one has over 1,000 signatures now, which is really great. And the ETU have collected 346, as you can see. So you can sign the petition online. So we'll definitely make sure we get the link out to you guys and you'll be able to pass it on to people via email. But we've also got a workplace kit that you guys can use to chat to people in your workplace about this campaign as well.
All right, so what I'll do is I'll, yeah, as Paul mentioned, we'll send out the online link for you guys to sign and disperse that petition through too. And what we also have, so just a reminder again, if you just head to the handouts tab and just click any of those hyperlinks. These are just the resources we're discussing at the moment. Once you click them, they'll download onto your desktop. So one of the ones we have up on the screen at the moment is our industrial manslaughter action kit. Now this kit is a perfect kit for you to be able to organise in your workplace and speak to some of your co-workers about being able to sign this petition. So getting your DWG basically to collectively put their hands up and say that they do want to see industrial manslaughter happening in Victoria, and just to get them to sign the petition. Now you can, yeah, as we mentioned, download this and print it out into your workplaces, or of course pop into Trades Hall. We'll give you a nice copy. And what we do with the hard copies is that we get you to run the script that we have available on the screen. Just a few talking points, but of course, if you want to say it in your own way, you're more than welcome to say it in your own way. Obviously, the more of a lived experience, the better it is. And then once your DWG has been able to sign it, you can either send in the petition by the reply paid envelope that, as I said, we will give to you if you come in to get a hard copy, or if not, just email the photo in, message us on our Facebook page, or send it in to ohsuorganiser@vthc.org.au. And now the other resource we have are our campaign posters. So as you can see, we have 2 available here. So the some bosses are getting away with manslaughter. And a very popular one that we have is the analogy of a maximum jail sentence for animal cruelty being 2 years, and yet the maximum jail sentence for industrial manslaughter being nothing. So feel free to download these and print them out, or come into Trades Hall and we'll happily give you a poster pack to spread around into your workplace and your community. And now the last resource we have available, now we will get this done up into a nice PDF for you guys, but you can download it now as is on the screen. And this is just some talking points for HSRs. So when you do go around to your workplaces and you're chatting to your DWG with the industrial manslaughter kit, you might come through quite a few common questions. So we've tried to cover these as best as we can, and also including some common answers and questions. So what is industrial manslaughter, why we need it, what the gap is in the legislation, so what it is that our current act can't cover, and why what we want to see to make sure that the gap is closed. We have a brief little outline of a comparison of workplace fatalities in Victoria since 2000, and here are some of the tricky questions you might get. So you might have some people saying that employers don't intentionally kill people. And of course, we understand that, but here's some easy ways to address some of those common replies. So as I mentioned, we'll have this available for you, and I'll include this in the link as I send out copies of the recordings. So now let's head back to our PowerPoint. All right, now, we've had a couple of questions come through, but at the moment I'm unable to collect them. So we've had a few sent in a little bit earlier. So I might go through some of those previously sent in questions. And if we don't have the time to get through some of the other ones sent in today, please feel free to email them to us at ohsuorganiser@vthc.org.au. And again, that email address is available on the screen. All right, so.
It might also be worth using the chat box as well, guys. So if you can see the chat box there and you've got a question you'd like us to answer now, please. We can see people have been using the question function, but at the moment, our computer's not opening the question pane, which is really frustrating.
Very frustrating.
So we just ask you to add your question to the chat box where we can see it. So we might just write hello in the chat box again, so you guys, so it pops up on all your screens. There we go. So we've just said hi, guys. So if you want to punch in any questions below there, we'll try and answer them for you now. Otherwise, those 7 questions have been submitted. We'll make sure we get them out of the back end and follow up on them for you.
All right. So one of the questions that was sent in earlier was that they were just wondering, doesn't recklessness already cover what we're trying to do with these industrial manslaughter laws?
It's a good question, and I think the answer is no. If we remember back to when we were talking about the different kind of levels of negligence, so recklessness is where the defendant knew their actions could cause harm and went ahead anyway, compared to negligence, which is failure to take reasonable care. And when it comes to industrial manslaughter, like that's actually what we're talking about here, is the failure to take reasonable care of employees or members of the public in such a manner that it causes the death of either a worker or another person. We feel that one of the issues around WorkSafe prosecuting recklessness is that the bar is so high, which has resulted in only 2 prosecutions. So we feel that if we want to get a law that's effective, we have to use the lower bar of negligence. Finally, I would note that is on a par with what is in the Queensland laws and also the ACT laws. So again, even if we're asking for negligence, we're just asking for the same level of protection that workers in other states have.
Yeah. All right, now I've had a question submitted by someone who clearly is working in the social services or health and community services sector, and they're kind of wondering will these proposed industrial manslaughter laws cover situations of patient to patient or client to client deaths? So yeah, is that something you reckon it could go through?
I think that there's a potential for that stuff to be caught under these laws. If we're going to write a law that says where there's a victim, so that victim could be a member of the public, so we capture behaviour like Growcons, then theoretically, yes, employer negligence, which results in the death of a client or a visitor to a service or something like that, that would theoretically be caught by these laws. What I would say is that worker behaviour would not be caught by these laws. So what we're looking at is negligence from a company, from an employer, and from senior management. So senior management, people who have managerial responsible for a significant part of the business. So people who work, frontline staff who work in accordance with standard operating procedures written by managers and that kind of stuff, they would not be caught by these laws, only the senior management and only the employer. So where an employer or a senior manager has been negligent and that has resulted in the death of a client or a member of the public, yes, they will be caught under these laws.
So to differentiate that, you're saying that if it's just a purely worker behaviour or employee behaviour, the laws will not cover this. But if that kind of death has occurred because the employer or management has been negligent in being able to control that risk and that risk was foreseeable, there's a potential for these laws to cover that kind of situation.
Yes.
Yeah. Great. Okay. And so does that kind of also apply to issues of workplace suicide or suicide perhaps for injured workers going through the compensation system?
That's a much trickier question. My initial response would be where there can be demonstrated employer negligence, which results in the suicide, then theoretically, yes, they would be caught by these laws. I think it would be much harder in the second example you gave where, an employer may have been negligent and that resulted in a worker suffering a horrific injury like an amputation, then ending up in the workers' comp system for the rest of their life.
Yeah.
And 10 years down the track, due to the pressures we know that exist in that system on long-term injured workers and the secondary psychological damage that occurs through that process, that person then takes their life. I don't think in that example the industrial manslaughter laws are going to apply because the employer negligence is not related to the suicide itself. What I will say is that even in the first example that I mentioned, where the employer negligence kind of is related, I think it will be difficult to demonstrate that through an evidentiary means. So I don't think many workplace suicides would necessarily be prosecuted under industrial manslaughter laws. What I think is that it would be theoretically possible so long as you could demonstrate the negligence crossover, that the negligence caused the suicide.
Yeah. And what about, we've had a submitted question asking if we're doing anything around International Workers' Memorial Day for this as well. Now, I believe we do have a couple of things planned. Did you want to talk further about that, Paul?
Yeah, so International Worker Memorial Day is coming up. The day is normally on the 28th of April. It's a global day for remembering those people who've been killed and injured at work. I think I've seen some statistics that there's like a person killed at work once every 3 minutes around the globe. There are some areas of the world where, people have seen news out of Bangladesh in recent years where there have been several horrific fatalities occurring where hundreds of workers have been killed in factory fires and this kind of stuff. So it's a really important day to mark the fact that there are still companies out there in Victoria, in Australia, and all around the world who put profit ahead of safety, and as a result, they kill people. And it's a day for us to pause and remember that. We traditionally here at Trades Hall run a memorial service. So on the Friday the 27th, we'll hold our memorial service at 11 o'clock in the morning. That'll be here at Trades Hall. We encourage everyone to get along. If you're able to get along on Friday the 27th of April, come down here. The service will kick off around about 10:30. It will culminate in a minute's silence at 11 o'clock and then some laying of flowers and wreaths. So you're all invited. We'd love to see you here. If you're unable to make it on the day, we'll also have something where if you want to hold a meeting in your workplace to remember those people who've died at work, we'll have something so you guys can do that in the workplace. The second thing we're going to do after the memorial service that we traditionally run is this year we're going to hold an industrial manslaughter campaign meeting. So we know that if we're going to be successful, we are going to have to convince a government to write a law that makes industrial manslaughter a crime. So we're going to need politicians to back in this law change. So we're currently talking to the government, the current government, the Labor government, about whether they're prepared to introduce industrial manslaughter laws. We hope to have an answer from them round about Anzac Day. So therefore, by the time we get to International Worker Memorial Day, we will know whether the Labor Party is prepared to stand up for working Victorians or whether they're going to try and squib it. So we're going to call a meeting on Worker Memorial Day on the day before, the 27th, when we hold our service, where we'll go through what the government's response is, and we'll have a chat with everyone about what the next step in the campaign is, given how the government's responded.
Mm-hmm, mm-hmm. Okay, so that's going to fall on part with the online petition and the kits.
Yeah, that's exactly right. So this is where the online petition is leading, right? Is at some stage, we're not only going to need to talk to people, we're going to need to start talking to the politicians, and so that petition becomes a tool for us and a way for us to start engaging with those politicians.
Great.
And we'll be holding that meeting directly after the memorial service. So the meeting will be here at Trades Hall. It'll kick off at around about 11:30. We'll put on a light morning tea so people have a bit of food and water while they're partaking in the meeting. But it'll run essentially 11:30 through to about 12-ish, 12:30 at the absolute latest. And it will really be about focusing on, we know what the issue is, we know how we want to fix it. So now we just need to convince the decision makers to do the right thing.
Great. And we'll be sending more information on both the service and the meeting afterwards, so keep your eyes peeled for that. Now we're running close to time, so what I'll make sure that we do is any of the questions that we haven't been able to answer that were submitted to us, we'll collate them into a little document with some answers to them, and I'll send them out as part of the normal procedure, where I'll send out a copy of the recording and the link to any of the materials that have been mentioned in today's webinar. So I'd just like to say thank you to Paul and thank you to everyone for attending today's webinar on the Industrial Manslaughter Campaign Brief. So of course, if you do have any other questions, please send them into Ask Renata, not to Ask Renata, obviously you can send any into Ask Renata, but specifically for the Industrial Manslaughter Campaign, please send them into our email at ohsuorganiser@vthc.org.au. Again, that email is on your screen. You'll also receive the follow-up email with a link to view all this recording on today's webinar and of course that Q&A document. So on behalf of the OHS unit at Trades Hall and of course Paul, we'd just like to say thank you for joining us this evening.
Thanks guys, it's been great.